And now the moment you've all been waiting for. The business panel. I'm Jess Bravin. I cover the Supreme Court for the Wall Street Journal. As I think we all feel, thank you to Professor Neil Devins and the William and Mary students and faculty and crew here for this event. It's I think it is to us in the Supreme Court world, like Labor Day for students. It's the end of fun and the return to work. We're very fortunate to have a great panel here on business law. A panel, if only the cases were worthy of the expertise that we have here, for litigators who really have had a huge influence on business law and other forms of law as well over the past decades. They don't need much introduction, but all of them have worked for the Solicitor General's office, and Paul Clement was in fact Solicitor General under President George W. Bush. He's now at Kirkland and Ellis. We have Carter Phillips, who's next in line at Sidley. Kannon Shanmugam at Paul Weiss, and Andy Pincus at Mayor Brown. He also was relevant to the business law discussion, General Counsel of the Commerce Department previously. So their expertise is great, and let's now squander it on the cases we have this year. We have two intellectual property cases involving state governments. And when I first saw Allen versus Cooper, I was hoping I'd be able to moderate our panel on piracy and law, but it turns out to be copyright piracy, but piracy involving one of the legendary privateers of the 18th century. I'm sure all of us know that 25 years after this school was founded, the ship that Blackbeard renamed Queen Anne's Revenge grounded off Beaufort, North Carolina, leading to about 300 years of litigation. And we're going to ask Paul Clement to tell us about that case and why it matters.
Well, thank you, Jess. It's great to be here. Really, the only reason to talk about this case was to be able to make a joke about pirates and copyright pirates and Blackbeard. So Jess has already done that. So I'm going to keep this. I'm going to keep this short. This case is really, in the end, I think a little less a copyright case than kind of a return to the 11th Amendment for the Supreme Court. As many of you may have known, like the Supreme Court about a decade and a half ago sort of went through pretty systematically and looked at a variety of federal statutes that provided expressly for a private damages remedies on behalf of private individuals against essentially any defendant, including expressly state governments. And the court pretty methodically and pretty much by a 5-4 majority, but one interesting exception towards the end, went through those statutes and said, no, you can't do that, Congress. There's an 11th Amendment problem. No matter how clearly you try to abrogate the state's sovereign immunities by making it crystal clear that you can bring a private individual can bring a damages action against a state in federal court. You don't get to do that, at least under Article I of the Constitution. And then they came up with a doctrine how you can sometimes do that under Section 5 of the 14th Amendment, the proportional incongruence doctrine. And there are a whole bunch of these cases where most of the time the 5 more conservative justices would vote to say that there was an insuperable 11th Amendment problem, and in most of the cases, the 4 more liberal justices would dissent and basically say, we think you're making all this up. The 11th Amendment doesn't even say this textually, and we're going to keep dissenting because we don't like this line of cases. And then, the court largely took 10 years off. But one of the last cases in the line was a case called Katz that I think to everybody's great surprise, or at least to my great surprise, the court, because Justice O'Connor, with like her last judicial act, kind of switched her vote and voted with the traditional dissenters and said that the bankruptcy code could apply to states, and notwithstanding the fact that the court had said pretty emphatically in a case involving patents that you can't abrogate state sovereign immunity under Article 1, the bankruptcy power, which is located in Article 1 of the Constitution, somehow got it done. I always thought that case, just as a footnote that's maybe more interesting than most of the rest about this case, I always thought that case was actually like a great case that showed the Supreme Court as a pretty awesome institution, because the Katz case came down literally on like Justice O'Connor's last day on the court, and the 4 dissenting justices, if they wanted to, I mean, they knew Justice Alito was coming down the pike. They probably had a pretty good sense that he had a different view of the 11th Amendment than Justice O'Connor was manifesting in that particular case. And, you know, they could have just sort of said, you know, our dissent's just not quite ready. We'd just like to fix a few more words, so we got to kick this over a week or two. And they didn't. And so the court issued this Katz decision 5-4, and it's really the only case that says that there's a continuing, only modern case anyways, that says that the court can abrogate 11th Amendment immunity under Article 1. So this case it does involve Blackbeard and photos of the wreck of the ship, which is pretty interesting, but none of that really matters for the issue before the court, which is just whether you can essentially, as a private party, sue a state in federal court for copyright infringement and get damages. Congress, plain as day, said absolutely. States can violate copyrights no less than anyone else, so you should be able to sue them no less than anyone else. That's generally actually kind of a bad formula, though, for winning an 11th Amendment case in the Supreme Court, because, you know, states are different from everybody else. So, you know, having clear congressional history that says that they wanted states to be treated like everyone else isn't necessarily such a great thing. But it's interesting anyways that the court took this case, because the lower courts had pretty uniformly said that, yeah, we're just going to apply the old patent case and some other cases and say that there's really nothing to see here. This is unconstitutional. This is the rare constitutional case where the SG presumably won't appear. They haven't appeared yet, and they've previously filed a letter with Congress saying, we think this is hopeless, so we're not going to defend it. I mean, it's phrased a little different, but that's the gist of it. And that's not a partisan thing either, because the first of those letters was sent at the end of the Clinton administration, and the most recent one was sent under Jeff Wall's signature. So kind of consistently, the SG has looked at this and said, no, we think the prior cases are controlling. So I think, you know, the safe money is probably on, well, certainly the safe money is on a 5-4 decision, I think. And the safe money is probably on the court saying, you know, the bankruptcy code is really, really different. And the copyright law is more like most things in the Article 1. And so, you know, this probably doesn't get it done. That's my sense of where the safe money would be. I'd say 2 interesting things. One is, given how, you know, fairly foreclosed this seems to me to be by the court's decision about patent remedies, I think it's pretty interesting, like, how much amicus support the petitioners have been able to get in this case, and, you know, that's a tribute to petitioners' counsel for generating that. They've also gotten some support in some somewhat unlikely places. I mean, you know, I wouldn't have necessarily thought a priori that the Chamber of Commerce and the Washington Legal Foundation would be kind of up for limiting 11th Amendment immunity of states, but they're on the plaintiff's, the petitioner's side on the case. And then there are lots of other people who just, you know, really, really like copyright laws and really, really think it's bad for the states to get to infringe them and get away with them. And that's a perfectly understandable impulse. That's clearly the impulse that manifested itself in Congress passing the statute. I don't know that that's going to move the needle too much from the 11th Amendment perspective. The one last thing about this I think may be interesting is I think the court could kind of in passing say something interesting about kind of the nature of copyrights. There's sort of a debate going on right now about copyrights and patents and how much are they like real property. I mean, how much are they like kind of true property that like conservatives should be really excited about defending against sort of infringement and taking, and how much are they just kind of like any other sort of regulatory, think about them as like, say, a state-conferred monopoly, which you'd think conservatives wouldn't think is so great. And there's a big debate going on about that in both the patent and copyright space. And the court could say something about this because one of the arguments as to why it's okay for Congress to abrogate immunity here is putting aside the Article I power, you can think about all of these various private damages actions preventing a taking from happening, because otherwise the state would be taking private property. And so that argument, I don't know how the court will react to it, but in order to accept that argument, the court would have to, I think, at least indicate that copyrights are some kind of like real property, not in the sense of land, but in the sense that they are true property interests. And if the court rejects that, I think it's probably going to suggest that no, copyrights and patents are a little bit more like regulatory provisions than not that special.
Can we talk about pirates a bit more? Because the facts of this case, just to briefly say what they are, since I have a feeling that my colleagues in the press may emphasize that angle more than the theoretical construct of copyrights. And that is that this ship, which ran aground, it was salvaged, and the state of North Carolina essentially made a deal with a private salvage company to bring it up, and since the state, I suppose, owned it or through its territorial waters, and the salvage company financed its operation by selling a documentary rights, in other words, to make a film about salvaging the ship, and the state, which owns the ship, got rights through this agreement to post some photographs and to distribute educational materials related to the ship. And so the question here is really between the documentary maker who says the state went too far and put too much material online for free, interfering with his copyright in the material, and the state says no. I would say that even if there is a right of action, the facts in this case are they're not open and shut, and the state even has a quite strong case just on the facts, even if it could be sued because they did post this material on their state website related to culture and education and so forth in North Carolina. Are there any other cases that we have that are similar to this that are floating around? I mean, where states are being sued? I mean, I suppose this is a state law school. They could publish a syllabus including all kinds of copyrighted works and be free of liability if the state of North Carolina wins?
Well, there definitely are implications for, and one of the things that the petitioners do very effectively is they point out that when Congress passed the statute extending the liability to the state governments, that they actually documented a lot of instances in which states behaved badly vis-a-vis copyrights, and a lot of that is in the university space. So that's one potential place where there could be liability if this case is decided that way. So the issue is really not whether states can violate the copyright laws, because of course they can, and it's not even whether Congress thought that they should pay for it because they were explicit. It's really just about whether they can do that consistent with the 11th Amendment. The one last thing I'd say just about pirates. Personally, Blackbeard is only my second favorite pirate, with my first favorite pirate being the dread pirate Roberts from The Princess Bride. And since that pirate's name is Roberts, somebody in the press corps ought to be able to do something with that. I hope. Anyways.
Thanks for the tip, as always. We have, amazingly, another state intellectual property case coming up from Georgia, and that has to do with it's the Georgia State Code annotated. And I'd like to invite Kannon to tell us about that bit of piracy.
Great, thank you, Jess. I had an even more elegant transition, which was that I actually once represented the alleged dread pirate Roberts, Ross Ulbricht, before the Supreme Court. But that's an issue for another day. I am going to talk about the other copyright case on the court's docket. it is usually the job of headline writers to make articles sound more interesting than they in fact are. And I pulled an article that two of my partners had written about this case, and the headline in the National Law Journal was, "SCOTUS to decide copyrightability of Georgia Code annotations," which I suspect did not provoke the good readers of the New York Law Journal to read further. But it turns out that this is actually a modestly interesting case, particularly if you're an employee of LexisNexis or West. Let me sort of lay out the facts of this case, and it's a pretty simple case, I think, to understand. The state of Georgia, like many states, has entered into an exclusive contractual relationship with an outside party to produce the official version of the state code, the Georgia Code. And in this case, Georgia entered into such a contract with LexisNexis. And as part of that contract, LexisNexis has the obligation under the contract to produce annotations for the statute. And at least the law students in the audience will know that those annotations contain commentary. They often include citations to other materials, law review articles, official opinions of the Attorney General, and the like. And the question in this case, at bottom, is a very simple one. It is whether those annotations are entitled to copyright protection under the federal copyright laws. Now, you might wonder why this is a question at all, and the reason why it's a question is because of a doctrine known as the Government Edicts Doctrine. And if you haven't heard of that doctrine, you're not alone, because I have to admit I had never heard of it until I started reviewing the briefs in this case. The Government Edicts Doctrine is a doctrine that was adopted by the Supreme Court in a series of cases culminating in 1888, which may explain why some of us have never heard of this doctrine. But it originated actually in a fascinating case called Wheaton versus Peters in 1834, and it was reported in 33 U.S. 8 Peters. And so the Peters of Wheaton versus Peters was actually, like the Wheaton, a Supreme Court reporter. And many of you will know that back in the day, as now, there is a reporter of decisions, but back then the reporter of decisions literally reported the decisions of the Supreme Court, and there was a question about whether the reporter could get copyright protection for these opinions that the reporter produced. And the Supreme Court in Wheaton versus Peters said no, on the theory that, in the words of the court, no reporter has or can have any copyright in the written opinions delivered by this court, and the judges thereof cannot confer on any reporter any such right. Now, in the wake of that decision, there was a precipitous decline in the number of applicants for the position of reporter of decisions. It became much less lucrative after the reporter was no longer able to get copyright protection, but the Supreme Court eventually extended this doctrine not only to its own opinions, but also to statutes passed by Congress. Now, fast forward to 2019, we now have a much more reticulated Copyright Act in Title 17 of the United States Code. And in, I believe, Section 105, there is an exception to copyrightability for the works of the United States government. There is no corresponding exception for works of state governments, but I think everybody agrees that at least the text of state statutes would fall within this Supreme Court created exception to copyrightability. The dispute in this case is whether the annotations are sufficiently analogous to the text of the statutes themselves to also fall within the scope of this doctrine. And one of the earlier Supreme Court cases did suggest that where you have annotations to court decisions that are actually produced by the court officials themselves, that they would fall within the scope of this government edict's exception. So there is some genuine ambiguity in the law. In the decision under review, the 11th Circuit said that the annotations were not entitled to copyright protection, and the 11th Circuit relied on the fact that these annotations were produced under the supervision of the Georgia Code Revision Commission, believe it or not, there is such a thing, which consists of the lieutenant governor and various members of the Georgia legislature.
That's what the lieutenant governor does.
The
Okay.
lieutenant governor supervises the annotations to the Georgia statutes. It's an even better job than being vice president. So Georgia and the commission go up to the Supreme Court. They say that there is a circuit conflict on this issue, and they seek the court's review. The respondent in the case, and I should sort of step back and provide a little bit of procedural background as to how the case actually started. What happened is that there is this group called public.resource.org, which is devoted to essentially making public various government resources. And they decided to just post on their website the official annotated version of the Georgia Code. Not surprisingly, they were sued for copyright infringement. And so it is in that context that this issue is being litigated. Georgia and the other plaintiffs in the copyright infringement case go to the Supreme Court and they say the 11th Circuit's decision is wrong and there is a circuit conflict. Public.resource.org files one of the more unusual quote-unquote briefs in opposition that I have ever seen. In this brief, they say there is no circuit conflict here. The 11th Circuit got it right, and you should nevertheless take the case. Which is not typically the way that briefs in opposition look before the Supreme Court. And, all I can say is that, number one, perhaps this group wants to run the risk of snatching defeat from the jaws of victory, but they were last seen winning in the 11th Circuit in the copyright infringement case, and so it strikes me as sort of an odd judgment to do that. I do think that oftentimes lawyers who represent respondents also have something of a conflict of interest where there is sort of a personal desire to get a case to the Supreme Court, but one would ordinarily think that it's in the client's interest to try to keep a case out of the Supreme Court. But this is a very unusual document, and perhaps not surprisingly, in light of the fact that the respondent really didn't dispute that the case should be in the Supreme Court granted review. Now that the case is in the Supreme Court, I do think that petitioners have a pretty high likelihood of success on the merits here. You often see these cases come to the Supreme Court where you have sort of a hoary old judicially created exception, and then you have plain statutory text. Here, I think that the statutory text, while everyone recognizes that there must be some form of an exception, I'm not sure that the court is going to have any particular incentive to read it broadly. And there is sort of a real sense that these annotations, were prepared by LexisNexis. The degree of supervision by the lieutenant governor and the other members of the commission was not very close. And you also have the Copyright Office supporting the petitioners here and arguing that there should be copyrightability. So I think it's somewhere between likely and overwhelmingly likely that the petitioners are in fact going to prevail and that respondent is indeed going to snatch defeat from the jaws of victory.
Did they copyright that brief of opposition? I was wondering, are there other states that have a similar setup, or is this unusual?
It is not an uncommon setup, and to be fair, that was one of the points that the respondent made, is that there are a number of other states that have similar setups. My interest in this case did not extend to digging into the statutes of all those states to see just how similar they are, but just from anecdotal experience, if you've ever looked online, it does seem as if LexisNexis and West, and I think Michie's back in the day, in many, many states, they have these sorts of arrangements simply because back in the day when there were actually books, I think a lot of states needed to have these contractual arrangements in order to ensure that their state codes would actually be published and widely disseminated.
Certainly in criminal cases, the Supreme Court has made a big point about there being fair notice to the public about what the law requires of them, and that's I wonder, does that principle that the court has spoken of run into conflict here, given the nature of this particular copyrighted material?
I think that is certainly one of respondents' arguments, the argument that, in some sense, this sort of, bundling, or rather that's sort of, I think, one of the arguments that really sort of both sides make. I mean, petitioner's argument is the argument that, you need to have this sort of incentive in order to ensure that there is publication. Respondents' argument on the other side is that, this is a very close adjunct to the statute. Some of the material that's contained is kind of quasi-official material, the opinions of attorneys general of the state of Georgia, and there's a sense in which, that if you feel that that is adjacent enough to the statutory text itself, perhaps respondent can get some mileage out of the fact that everybody agrees that the statutory text is analogous to, say, a judicial opinion and needs to be in the public domain. That was, after all, the genesis for the government edicts doctrine. I just think that the court is ultimately going to likely reject that premise and say that the annotations, feel like traditional creative material.
Even though the state has
I filed a brief in this case. It's interesting because there actually are Georgia state court decisions holding that the annotations have no legal force, which is sort of a problem for the respondent. But this case is a little bit of a stalking horse for a bigger issue, which is a lot of building codes and other laws incorporate privately designed and adopted codes of construction, fire safety, et cetera.
National Electrical Code.
And a lot of the ways those people support the effort to produce those codes is by selling them. And so there's a much bigger fight out there in the courts about whether those private codes that are incorporated into law can be copyrighted given their status as incorporation. And it wouldn't be shocking if one of the reasons the respondent wanted to get this case up there was to get the court, even if they lose, to try to say, well, yeah, these things don't have the force of law, so they are copyrightable, but these other kinds of things are on the other side of the line.
It also seems somewhat oddly as if, to the extent that there was other lower court authority on this issue, a lot of those cases did involve sort of like tax maps and other, factual permutations. So there is, potential broader significance of this beyond code annotations. So I kind of find it hard to imagine that there's going to be an opinion that isn't a fairly context-specific opinion here. I think the court will presumably be aware of, from the amicus briefs, these other implications and want to write narrowly.
Right, because we have seen a movement to put more material online and make it more accessible to the public, these sort of, documents and rules and, official records or quasi-official records. So it would be interesting if that, if they ran into a copyright issue restricting it. Let's now turn to something that involves an element really at the heart of most business cases, money. And we have before the court yet another Obamacare-related case, Moda Health Plan. And Andy, can you walk us through this and then help us file our insurance claims?
Yes. So for people who worry about the health of the Affordable Care Act, a grant by the Supreme Court of an Affordable Care Act case is sometimes cause for concern. But this case is different from NFIB and King and the cases that have come before, because whatever the court does, this is wholly retrospective. It has nothing to do with what the Affordable Care Act means going forward. And it has the additional wonderful feature that Paul Clement and the Chamber of Commerce are supporting the Affordable Care Act.
Big fans of it.
So this, just a little bit of background. The major reform of the Affordable Care Act was to create exchanges in each state that would sell insurance, and the insurance would be available to people with pre-existing conditions, no bar on people with pre-existing conditions, and it couldn't be rated based on the health of the insured or various other characteristics. There was some concern that this was sort of an unknown world for insurance companies, and their ability to price that in this new market where they were taking on risks that they really wouldn't know because they didn't know the health status of the people who were buying their insurance, could lead them to price their insurance at very high levels. So the Act included a number of protections and incentives so that insurance companies would actually participate in this new venture without the risk that they would, especially in the initial years, price their insurance too low and end up with health care costs that were way in excess of the premiums that they received. And this case involves one of those programs. It's called the Risk Corridor Program, which was effective for the first 3 years of the that the ACA operated, and said that there would be some reimbursement to insurance companies on a scale if their payouts in terms of health benefits greatly exceeded the premiums they took in. And there was, on the flip side, an obligation of insurance companies that were in the reverse situation, where they had priced their insurance such that they ended up having a surplus, would have to give some money back to the federal government. And the rules of the road for this program changed a little bit. Initially, there was some indication from the administration and regulations that these payments would be available regardless of whether the payments back were less than the payments that were obligated to go out. And then subsequently, the administration changed position a bit and said, well, no, this is all about a program where there's going to be a balance, and we're not going to use any appropriated money to fund this program. So fast forward to December 2014, which was the first year that Obamacare was in effect. And I think it was Senator Cruz, wasn't it, who introduced the rider? I think maybe.
No, Ruby.
Okay.
Ruby, yeah.
There was a rider in the Senate to the appropriations bill that said none of the funds made available by this act from either the trust funds that fund health programs or transferred other accounts from the HHS authorization could be used to fund the risk corridor program. The state of play after the 3 years that the program played out was that $12 billion in payments were owed, and about only 4% of that amount, I think that's right, could be financed by the payments back in from insurance companies. And so not surprisingly, the insurance companies that thought they were going to get this money filed claims in the claims court under the Tucker Act, claiming that the federal government was nonetheless liable for these claims because of the statutory obligation to pay them, or maybe because they had an implied contract based on the statute, or maybe because they had a constitutional obligation and the failure to pay was a taking. And so the questions were sort of, the basic questions were twofold. Was there an obligation in the original Affordable Care Act to pay that was sort of unequivocal and not dependent on whether there was an appropriation? And then what about the effect of this appropriations rider? Did it somehow vitiate an obligation that might have existed before? And the Federal Circuit said, well, it's clear to us that there was an obligation to pay. It's shall in the Affordable Care Act, and that seems to set up an unconditional obligation to pay this money, even though there's not an appropriation. But we read this appropriations rider as essentially repealing that obligation, and therefore the federal government doesn't have to pay. Lots of insurance companies petitioned, 3 cases granted, and the question before the court, I think, will end up being both of those questions. The topside briefs have been filed, and they obviously focus on this question of repeal, the impact of the appropriations rider, and what does that mean. And I think, as folks know, repeals by implication are not favored generally, and there is some pretty good authority that in the appropriations rider context, courts are particularly skeptical that an appropriations rider somehow repeals some underlying obligation. And of course here, the appropriations rider is pretty specific. It doesn't say no federal funds. It says none of the funds made available by this act, which seems quite limited in terms of its effect. So lots of agreements on the fact that this appropriations rider doesn't make a difference, and that therefore the underlying obligation stands, and the court through the Tucker Act has an obligation to pay this money, make sure this money is paid by the federal government. And I think, sort of zooming out, lots of questions. It's not unusual for there to be statutory language that's mandatory, not necessarily accompanied by an appropriation, and the federal government taking the position that without an appropriation, we don't have an obligation to pay this money. The Anti-Deficiency Act, which people who've worked with the government is familiar with, makes it a crime actually to pay money that's not authorized by law. So often the General Accounting Office and other government agencies say you can't pay this money without an appropriation. On the other hand, there's a judgment fund created by statute that says there's a continuing appropriation when there's a judgment against the federal government. And so The big picture question is, if there's mandatory language saying the government shall pay, does that mean in almost every case, even if there's no appropriation, the person who's owed the money can go to a claims court, file a case, and get money? Obviously, a big concern for the federal government. On the other hand, the federal government increasingly relies on private parties to do things. If they rely on the fact that money is supposed to be available to undertake some obligation, should the government be able to welsh, essentially, based on the fact that turns out that there's not going to be an appropriation, or that some subsequent rider like this, while the program is sort of midway through, vitiates that obligation? So, an interesting question. It's especially interesting, I think, for Affordable Care Act watchers, because of course there was another question about payments under the Affordable Care Act. People may remember there was a case called House of Representatives against Burwell that dealt with the part of the Affordable Care Act that required the federal government to pay the copay payments for people who were getting subsidies under the act. And the House sued and said there's no appropriation for that, and therefore it can't be paid. And the president, when the Trump administration took power, suspended those obligations. So an interesting question about how this case, if it comes out in favor of the insurance companies, will affect those CSR obligations as well.
How much money remind me, is at stake in this case?
$12 billion.
$12 billion, okay. Paul, since you're arguing, anything you'd like to add to Andy's summary and why it matters and how you got so excited about enforcing the Affordable Care Act?
Well, see, this is a case, I think, that even somebody who might think that the Affordable Care Act either shouldn't have passed or might have been unconstitutional would nonetheless say, no, the government can't do this. I mean, this case, I think, really does come down to a question about whether the government can effectuate a $12 billion bait and switch. I mean, and I think Andy's right that I think the government will try to sort of relitigate the question they effectively lost in the Federal Circuit, which was the original promise sufficiently clear? But, the government's position is that no matter how clear their original promise to pay, and no matter how much people sort of relied on that promise to perform and incur substantial reliance costs, that unless there was appropriations for the first year of the promise, if the government just says, the Congress in 2011 thought it would be really good to have this program and make very clear promises to pay in 2014, but we're a different Congress, and we're just not going to appropriate any money. That, like, the government's position is then they don't have to pay. And, I mean, A, that seems kind of crazy to me. B, that seems like it's not in the government's own long-term best interest. Because, this is kind of like Lucy in the football. Like, you only get to pull this move so many times. And if they successfully pull it here to the tune of $12 billion, like, who's going to ever rely on the government's promise that they're going to pay them down the road if it depends on a subsequent appropriations, especially because if you get into, like, the nitty-gritty of this case, I mean, part of what's going on is that, by the time it rolls around to appropriate the funds, you now have the Republicans controlling the House of Representatives, and they still don't think much about the Affordable Care Act, and so their attitude is kind of like, hey, Obama administration, you got yourself into this fix. Where are you going to come up with the $12 billion? We're not going to appropriate it. And that's a dynamic that could play out, in any number of administrations and Congresses over time. And so I think, frankly, it would be a dangerous precedent for the government itself if it turns out that they just can't ever essentially make a promise that's enforceable that they will actually deliver on in subsequent appropriations years. Because, again, without boring you about the details of this, like, there was no way, like, the government couldn't even figure out how much it owed people until the year after there was performance and everybody sort of tallied up what they paid out and what they took in. So this can't be the only context where it's really useful for the government to be able to represent to people, look, we need you to do certain things, and we need you to incur certain sort of reliance interests and the like. But don't worry, we're gonna pay for it, and we're the federal government, we're good for it, what could possibly go wrong? So I do think the precedent that will be set in this case is actually kind of going to be important generally for the federal government.
There's sort of a fun text versus legislative history aspect to the case, too, because as I said, the rider is actually quite limited, but the government's explanation for why it should be read as a prohibition on any federal funds being used to fund these payments is that there was a request to GAO for sort of an identification of what funds would be available, and the response was, these are the two possible sources. And so that's why the rider was drafted that way, and so you really should consider that and interpret this as a broad prohibition of federal funding. So it's sort of fun for the text versus legislative history.
Yeah, I think one or two justices, and I won't name names, but I think one or two justices were going to have some fun with the argument that, never mind the text, the reason we know the statute did what we want it to do is that there was correspondence between the GAO and two congressional offices. I think that's going to be fun to watch.
Paul, I have a question about this. What would happen if, rather than doing what Congress did, they just revoked the promise? How would that be analyzed? Would that be analyzed as a matter of retroactivity at the threshold? Would it be a takings issue?
I think those are good questions, and I'm pretty confident that my clients would be saying it's some form of it's either a contract sort of WinStar, or it's a taking, and I'm pretty sure the government would be saying we don't owe you anything. And I will say one thing that's interesting about this case, just having gotten into it because I wasn't involved in the lower courts. This is not a case I've been thinking about for a long, long time. I would have thought that the answer to most of these questions had been settled in roughly 1804, or certainly after a bunch of people didn't pay for things after the Civil War. But the answers to these questions are not as clear from prior precedent as you might expect them to be.
Is the government trying to, I noticed just in leafing through the briefs that the government seemed to invoke at least some of the retroactivity case law. Do we think that that's the argument they're going to try to make here?
Well, they only invoked it defensively. So one of the points that we've made is whatever the rule generally, it's particularly problematic here because it was December 2014 when they were appropriating money for the 2015 appropriation cycle where they basically made clear that they weren't going to pay people for 2014. And I think where the government's position is more clear, and some of the cases that they have going in their favor is so in 1925, Congress says we're going to suspend the reenlistment bonus for service people, and then in 1928 somebody says I'd like my bonus because there's an old statute that says I get the bonus, and you just didn't appropriate enough funds for it in 26, 27, and 28. I mean, there I think the government's position at least says, no, it was clear enough from the appropriations that we were no longer doing that. That's a reasonable position, but I think it's a much, much harder position to sell to say, yeah, we wanted you to perform in 2014, and you couldn't possibly have known that we weren't going to pay you in December, but nonetheless, we don't owe you a penny. That's pretty tough.
Where would the money come from if the government is required to pay it?
The judgment fund.
Oh, they have a okay. all right.
There's this continuing appropriation for judgments.
I see, okay.
I mean, in fairness, though, which is to say, from your wallet and your wallet and your wallet. The judgment fund is just not like a big pile of cash in Beverly Hills. I mean, it would have to be. It's a mandatory appropriation. So if something comes out of the judgment fund, it's not discretion. Congress can't pull this when it comes to the judgment fund. So they can't say, yeah, we owe hundreds of litigants millions and billions of dollars, but we're just not going to do anything with the judgment fund. So that's.
And it has $12 billion in it right now?
It has the capacity to get $12 billion in it through the mechanism of your wallet.
Oh,
Yeah.
It is there's no ceiling on it, but
Right.
it obviously
So it
contributes to the
automatically
deficit. Yeah.
increases to meet the needs of your clients?
Yes,
basically.
it's refunded magically every April 15th.
The sympathy for Paul's position just dissipated throughout the room. The Clement tax increase of 2020 is not too far away.
Interest in full disclosure.
Talking about government obligations, as a transition. Where we have another major case. This one also involves, I think, a lot of individuals' investments around the country, and also the status of Puerto Rico. That's the Aurelius investment versus Puerto Rico and related cases, and we're excited for Carter to walk us through them.
So I realize that I am the last thing between you and lunch, so I will try to be at least somewhat brief, but indulge me for 2 seconds to make a comment on the previous case, because the sense of deja vu all over again. I argued the Rama Navajo case against the United States several years ago, and in that case, the United States government entered into contracts with all of the Native Americans to provide services on the reservations. They offloaded U.S. responsibilities to them. All the Native American groups did all of this work. And then the federal government came back and said, oh, well, we don't have enough money to pay you all, so we're just going to pay you on a pro rata basis, but you should be perfectly satisfied with that. And the Court of Appeals upheld that, saying, oh yeah, okay, that works. And so I took it to the Supreme Court, and I thought to myself, this is a pretty remarkable proposition, right? I can go out and enter into all the contracts in the world, and as soon as I run out of money, I just say, well, I'd love to pay you, but I don't have any money. It seemed to me a pretty counterintuitive contract principle. I won that case 5-4, so it always scares me when anytime you litigate against the United States government, especially when it's got a lot of money at it, you do have to worry at least a little bit, and so it's I don't put that out of mind. Now, with respect to the Puerto Rican case, first of all, the plaintiffs there are significantly less sympathetic than Paul's.
Than insurance companies.
Than
They're
insurance
less
companies.
sympathetic than insurance companies.
So these are hedge fund vulture investors who have accumulated a significant amount of bonds, a large sum of bonds, billions and billions of dollars of these bonds from Puerto Rico. Puerto Rico obviously went into extraordinarily hard economic times, and candidly continue to be in hard economic times. And unfortunately for Puerto Rico, they did not have the benefit of the bankruptcy code to allow them to intervene in some meaningful way to relieve those debts. But fortunately for them, Congress did in fact pass a statute in which it created a special board to help essentially Puerto Rico to reorganize its debt situation. And it appointed the members of the board in a very specific way that Congress identified, which is that the president could, without using the advice and consent of the Senate, adopt pick names provided to him by the majority leader, the minority leader of the House and the Senate, and et cetera, and then he could pick his own person as well. And it didn't have to go through confirmation process. And so that was the board, and it was put in place. And it did what what a bankruptcy court would ordinarily do in order to try to reconcile all of these obligations of Puerto Rico. And candidly did it in a way that was much more beneficial to pensioners of Puerto Rico than it would be to the creditors of Puerto Rico, which is why the creditors are outraged by this particular situation. I think the pensioners are either being covered 100% or some 90-some% of what the obligations would be for them, whereas a lot of the creditors are going to end up with literally pennies on the dollar in terms of the way this gets allocated. The clever theory that the hedge funds came up with for why this would be impermissible was the notion that they hadn't been properly appointed, that the members of this board were not properly appointed under the Appointments Clause of Article 1, and that as a consequence of that, all of their actions are illegal, and therefore you got to start all over again with properly appointed individuals. The case goes to the district court, and then in the First Circuit said, yeah, that's right. You have to abide by the Appointments Clause. It does apply in Puerto Rico, but there's a de facto officer exception to the principle. It says that under certain circumstances, even if you haven't been properly appointed, you don't have to start fresh. You just have to, you can ratify in some respects those appointments after the fact and get around the problem. The petitioners took that case to the Supreme Court, and the Supreme Court granted certiorari. the court has been very concerned about appointments clause issues. The SEC case from a term or two ago, the court said that, administrative law judges had to be appointed in a particular way. And they didn't adopt a de facto rule for that situation. They just basically said, look, if you're going to go back, if that's what you're going to do, you're going to have to appoint brand new administrative law judges, and you're going to have to start over. That's one thing when you're talking about the number of SEC cases that have been decided by administrative law judges. You can probably count that in maybe not on two hands, but two hands and two feet will probably get you. The retroactive effect of that was not all that significant. Here you're talking about reorganizing literally hundreds of billions of dollars of the Puerto Rican economy, and if all of that's now been undone, you will obviously create an extraordinary disruption to an economy that's already suffering badly enough. So that's how the First Circuit got out of it. Candidly, the way this is all going to turn out is going to have nothing to do with the Appointments Clause. It's going to have to do with Article 4, which has a provision that allows Congress to make all needful rules covering territories and possessions. And obviously, Puerto Rico is a territory of the United States and has been recognized as a matter that Congress has very, very broad discretion. It doesn't have enough discretion to avoid the presentment clause of Article 1, but generally speaking, once you get out of that, Congress can pretty much structure Puerto Rico however it wants. And so in this board, which it's created, it sort of sits somewhere between the federal government and the state government in the sense that it has authority to tell the Puerto Rican government, to tell all the Puerto Rican government officials what they can and cannot do, which is pretty cool power to have, I would guess. But it's not part of the federal government in that sense, or at least it was designed not to be part of the federal government under those circumstances. So are these officers of the United States, if this were in some other circumstance, my guess is the answer would be decidedly yes. But because it's Puerto Rico, because Congress has much broader authority under Article 4 to deal with Puerto Rico however it wants, it can structure this governmental scheme in any way that it wants. And I don't see any likelihood that the court's going to revisit that. Now, Jess asked me to, what does this mean for the insular cases in which Congress and the federal government have, over the years, done some extraordinarily negative things to Puerto Rico? And the answer is I don't think it's going to have anything to do with it, because the court's not going to revisit those issues, other than perhaps in passing it to make an apology. But other than that, because they've done that before in some situation, but I don't think they're even going to do that here. I think they're just going to say Congress can do what it wants in this context, particularly when the situation would otherwise be pretty disastrous. And I don't think the court's going to be, I mean, they're interested in the Appointments Clause, but I don't think they're going to be interested enough to reach out to get at that issue in this particular context. So.
Thanks, Ray. Yeah, I think that I was interested in that only because the legal status of Puerto Rico is it's something certainly that the Puerto Rican government is very aware of, and the Supreme Court has had a few opportunities in recent years to comment on that, and in every case has really diminished Puerto Rico's standing as anything near a state. It's really treated legally essentially as a colony and has no power whatever over its own affairs other than what Congress chooses to give it. And so the Puerto Rican government tends to bring that up a lot in its briefs, and I think some of the other amicus briefs also discuss the unusual legal status of Puerto Rico in this case. But and because if it was a state and it had the same economic situation and the same issue with its bonds, its remedies would be very different under the bankruptcy code and sovereign immunity and elsewhere. So we are just about done, but first I do want to see if there are any questions we have about the business cases this term.
I have to say, the thing that's the most disappointing is that when I originally got put on this panel, I was thinking to myself, oh, it must be punitive damages cases, class action cases, implied preemption cases, implied dormant commerce clause, all the things that are the grist for the business law mill, and we had none of that stuff. And we don't even have any interesting antitrust cases or interesting Securities Act cases. It's really
Not even arbitration.
it's miserable.
Well, it's time well spent, isn't it? But let's have your question.
Sorry, you just, a while ago, you said there was something fun involving something called
GAO.
GAO.
Government Accountability Office.
Yeah.
I had no idea what you were talking about. I just had no idea. And so I was hoping.
So just this
By the
sort
way,
of
the concept
interesting,
of fun and the GAO
Yeah.
in the same sentence is unbelievable by its nature.
grimmest-looking building in Washington. No, the fun thing is this text versus legislative history. So the legislative history is this correspondence between Hill offices and the GAO, which is sort of the government paymaster. And so the justification for reading the narrow language of the appropriations rider broadly is that this correspondence told told Senator Rubio's staff essentially that these were the only two sources of federal funds. So you should therefore interpret this appropriations rider, the government says, to bar all federal funds, even though it only targets these two sources.
Yeah, and just the broader point there for students is that in terms of legal method, some justices prefer only to look at either exclusively or almost exclusively at the text of the statute itself, and anything extraneous, even if it's related to the way the law was passed, like this correspondence between officials, they don't want to see it. They think all that matters is the actual words of the statute. Other justices are more open to looking at other material that might inform their understanding of the statute. And so, because this is one of the really methodological issues that we see at the Supreme Court, Andy is excited to see how it may turn out.
Find your fun where you can.
That's right.
Take different cases so we have a lot more fun.
All right, well, Sammy's going to have a public service announcement in a moment, but before that, I wanted to again say that, these fellows are some of the best advocates at the Supreme Court. You heard them make a great meal out of some leftover grist today. I'd encourage you to go to oea.org and listen to them argue. All four of them have many oral arguments before the Supreme Court that any of you can listen to without, and there's no copyright. Am I right? That you don't have to pay to hear them argue and interact with the justices who throw them questions. So a big round of applause, please, for